Civil society organizations plan to challenge Parliament in court over the Electoral Amendment bill. They sent a letter to the Portfolio Committee on Home Affairs questioning whether that bill would be constitutionally sound if enacted. The National Assembly yesterday voted in favour of that bill, or the amendment bill, I should say. President Ramaphosa now has 2 months to decide whether to sign it into law. Changes to the electoral system would allow for independent candidates to contest in national and provincial elections.
Changing an electoral system takes much longer. So what we did was just to accommodate independence as the Constitutional Court has instructed. I can assure you there was no way in 24 months that we could have done. Whether changing an electoral system will be undertaken in such a short space of time, and my answer is no. That's why what we did was just to insert independence within these 24 months.
Let's get the reaction now of Bulelani Mkholiswa, the the spokesperson, coordinator, I should say, for the New Nation movement, also executive director there. Very good afternoon to you, sir. Grateful for your time. I don't know if you were able to hear the Home Affairs Minister there basically saying that there was no way in 24 months there was going to be a wholesale change of the electoral system, and that was never what this process was meant to do. A conflation, he says, is what has happened now of issues in the outrage from NGOs. What do you say?
Well, Thembekile, first and foremost, thank you for having us. It's always a privilege to speak to the nation. I was listening to the clip that you just played of the Home Affairs Minister, and it's always sad to listen to politicians making these kinds of statements, because the reality of the matter, even when we were asking, when we were taking this matter to the Constitutional Court, the Speaker had requested 36 months for them to be able to implement whatever the Constitutional Court was going to vote on. And we said it must be 24 months because we understood that the possibilities of them playing these mind games and delaying tactics was always going to be there. And it's amazing that also the fact that when the judgment was handed down on the 11th of June in 2020, it took them about 7 to 8 months before they could start doing anything about it. So it's amazing that they are complaining about the shortness of the time. But the reality of the matter is that we had tried to engage with them, and not just the New Nation movement, but many other groupings. And we were making suggestions that were going to make their lives very easy, but they did not play ball at all.
And you initially went to court over this issue. For the people who weren't following this process from inception, let's go back a few steps and talk about why you felt it was such an important issue to challenge legally.
Well, I think, Thembekile, the reality of the matter is that South Africa has been on a downward spiral for a number of years. And many people have tried to voice those concerns, others by burning down structures, and there are many things that have been done. And we said maybe the contribution that we can make outside of being political parties as a civil society is to actually take this matter and use the constitutional democracy that we enjoy to the benefit of all. And which is why we felt that maybe the best possible way of resolving the corruption issues that we are currently experiencing, it would be through going to the Constitutional Court. And that was the reason why we took the matter to the Constitutional Court.
With that noble goal in mind, then, are you hopeful that during the other steps, this bill may indeed be prevented from passing in its current form? Because, yes, the National Assembly has voted in favour, but it still has to go to the NCOP as well.
Well, I think history has shown us that the NCOP is always taking the directive from the National Assembly. So we're not expecting any different response from the NCOP. And it is very sad and unfortunate that, this Parliament has missed an opportune time to make a significant change and progress in deepening our democracy. And unfortunately, they've chosen, to take this view of wanting to hold on to power, even if it means it's unconstitutional to do so. I mean, if you look at Section 18, it talks about the freedom of association. And our electoral laws, as they currently stand before this amendment bill, it just forces people to go and serve in the national and the provincial legislatures via the membership of political parties. So even that right for freedom of association has been taken away. But if you look at Section 19, it then goes even deeper. It says every adult citizen has the right to stand for public office and, if voted for, hold that office. So political parties are literally saying that doesn't matter. They are the law of the land, and they would want to hold on to that power, even if they are ordinary South Africans who know that they can make a significant contribution in resolving some of the challenges that we're facing in the country.
And Minister Motsoaledi, I'm not sure if you would agree, appears to believe that the bill in its current state is basically a start to a broader, shall we say, campaign to level the playing field for people who want to contest in that electoral space, and more can be done beyond this, even past the period of 2024 perhaps, when the general election comes around. Would it be a good start? Would it be enough as a start to broader change?
Well, we will always have to question the intentions of the Minister of Home Affairs as to the bona fides and whether they really does that point that they are not acting in good faith. I mean, even within the 24 months and even the 6 months that they've asked for as an extension, a lot could have been done so that the bill could have looked much better than it currently is. One of the things, Thembekile, that we had proposed was that South Africa is currently divided into 9 provinces, but when you go further down, it's divided into 52 districts, which is 44 district municipalities and 8 metros. So we're saying, why don't we take those existing demarcations as they are, so as to save time, and use those 52 districts as constituency assemblies or citizens' assemblies, that people can be able to exercise and express their chosen and their desired options as to who they would want to send to Parliament. And Minister Motsoaledi has ignored all those. And I think one of the things that is important even to mention, Thembekile, is the fact that the process that we are seeing now being undertaken of the electoral reform, it's not even an overhaul, it's just a minor tweaking here and there. It's not because of the benevolence and the graciousness, of the ruling party and Parliament. It's because we, the New Nation Movement, took this matter to the Constitutional Court, and the Constitutional Court instructed Parliament to remedy the situation within 24 months. So the bona fides and the good intentions of Minister Aaron Motsoaledi are very questionable at this point in time.
Given where things stand then in terms of the National Assembly vote and upcoming processes which may indeed see or lead to the adoption of this bill as law, where does that leave you in terms of options? Will you go back to court, challenge it?
Well, remember, Thembekile, the matter was supposed to be constitutionally sound.
Yeah.
And as things stand, it does not look like it's coming any close to being constitutionally sound. So that means that our work has not been completed. We still have to go back to the Constitutional Court. In fact, when they asked for extension of 6 months in Parliament, asked for the extension of 6 months, we then suggested to the Parliament and to the Constitutional Court to say 6 months is not going to be sufficient to bring substantive changes, and that will be in line with the spirit and the letter of the judgment. Let's give Parliament or even the Home Affairs 12 months so that there could be some sound and proper, alterations and changes within the amendment bill. Unfortunately, our pleas fell to deaf ears, and the Constitutional Court said that might be premature. Let's allow Parliament, and that's what we have done. And it looks like they are not measuring up to what the Constitutional Court judgment was requiring them. That forces us to go back to the Constitutional Court.
Bulelani Mkholiswa, good to have your time with the New Nation Movement. He's coordinator and executive director.